Hi, everyone. Welcome to this week's weekly live immigration attorney chat here at Immigration for Couples. I'm attorney Megan Pastrana, and I'm happy to be with all of you here today. I see we have some comments already coming in, so that's wonderful. I am streaming this live on Facebook, LinkedIn, YouTube, and Instagram, and I answer the questions in the order that I receive them. I normally host this, my team and we normally host this on Tuesdays at 11 a.m. Eastern Time. It's just a busy month this month with holidays, and I have a lot of clients with interviews that I'm traveling to all over. So we're moving the lives. So that's why we're having it here today. Next week, it'll be on Wednesday. As long as you subscribe or follow, depending on where you are watching this. So if you're on Facebook, LinkedIn, YouTube, or Instagram, just be sure subscribe, follow, and then you'll be notified when the next live event is scheduled. After December, we'll get back on track with our normal Tuesdays at 11 a.m. Eastern Time. All right. All right. And I do see that we have a lot of questions coming in here. So I'm going to jump over to those just here in a moment. A couple quick reminders if you are, and maybe they're not reminders, maybe you're new here. So like I said, welcome if this is your first time. We host these weekly live chats. We know going through an immigration process, it can be very stressful and overwhelming, especially with the copious amounts of policy changes that are happening on an almost daily basis. So we host these live so you have a community, a place to know you're not alone, so you can get updated information. We also have a free resource center, immigrationforcouples.com. You can download a free chapter of my book about how to prove your relationship is real. And Ria's throwing those in the comments as well. And I always like to ask, where are you at in the world? Where are you at in your immigration journey? And the very most important question, how are you doing? Especially right now, how are you all doing? And you can answer all of those, some of those, if that feels aligned for you. And then go ahead and keep throwing your questions in, and we'll start going through those here momentarily. All right. So let's see. Eddie, it looks like you're first here. Hi, Ed. It's nice to meet you. And I don't know if you have any questions here today, but thanks for being with us. It's great to have you here. Betty Ann, I see you're with us again. That's exciting. I know you've been making a lot of progress on your case. You're in Canada, and you'll be flying to Eastern Canada on the weekend for your interview. I bet you are feeling very excited. You're getting closer, so that's fantastic. And congratulations again. We're all so happy for you. All right. And Monica, you're watching from the Philippines. Great to have you here with us. All right. Without further ado, then it looks like I have my questions here, and I will start going through those. So you had your adjustment of status interview. It was based on a K-1 visa. On December 15th in New York City, you updated your address to Chicago, and USCIS canceled the interview. Should you switch the address back or leave it? If you move during your immigration case, legally, you must update your address with immigration within 10 days of the move. They take that very, very seriously. The reason being is that if you're going through an immigration process, you have to have your interview in the jurisdiction where you're living. In other words, the place where you're living, that's where you have to have your interview. So if you're in Chicago, your jurisdiction is no longer New York. I know you said that it was a temporary move, so I'm not sure all of the details. Definitely, if we have clients that have a temporary move, we ask a lot more questions about what that move looks like. Is it for work? Why is it temporary? We need to understand that before we're doing address updates. Because if you do have an interview scheduled and you have a change of address, of course, they will cancel it and they'll move it to Chicago. So I don't know where you're living now. If you've moved again, then you need to update your address again. So I can't tell you, I'm not going to tell you to switch your address back because I don't know where are you actually living. Because where you're actually living, where your physical address is, where you're residing, where you're living at, that is your address. And so that is the address that you should provide to immigration. So if you are in Chicago now and you've updated that address and you remain in Chicago, then that's where your address should stay unless you move again. All right. So yes, great question, Sarah. I'm sure others have that question too about moves. All right. Okay. Hey, Rochelle, it's great to see you. Yeah, so you're wanting to know about the travel ban, the pause on immigration, and all of those changes that have really happened. I mean, the initial travel ban was in June of the 19 countries, and then it has expanded to a full pause as of last week. And so you're wanting to know how it could impact other countries. So right now, the policy update that was received as of last week, it says that those 19 countries, and I made a video about that. Ria, you could post that as well, Ria, if you are able. I have it on all of the social media platforms. You could just grab the one from YouTube. But right now, the pause is applied to those 19 countries, and the pause is on all applications. However, the policy was not very very thorough or very clear, as is a lot of the policies that have come from this administration. And right now, the policy notice is for USCIS applications. It's not clear if that would expand to work permits, but it does say all applications. So USCIS is in charge of reviewing the initial petition. So if it's a spouse visa, they review that I-130. If it's a fiance visa, they're reviewing that I-129F petition. So USCIS is the part of immigration that reviews those applications in the United States. But for spouse visa cases, there's a part that involves the Department of State, U.S. embassies and consulates abroad, because a U.S. consular officer is who has to adjudicate or decide the spouse visa. It's not clear how it's going to be applied for this like spouse visa process with the U.S. embassy. We anticipate, immigration attorneys, we anticipate seeing that there'll be an expansion of this policy to also incorporate decisions at U.S. embassies and consulates. And right now, it is limited to those 19 countries that are in the policy and that travel ban from June. So it looks like Ria threw that video in there as well. So right now, I think your main question, to get to it to be as clear as possible, is Egypt. So Egypt's not on the list right now. And I know a lot of individuals were reaching out and saying, hey, what about, Nigeria or Philippines and countries that aren't on the list? I can't even begin to speculate if other countries will be included on the list. I mean, there's definitely been rumors, and then there's also been comments made by this administration. But right now, as of this moment, it is those 19 countries that are on the notice from December 2nd, and the policy update rather from December 2nd. So Egypt's not on there. Could it expand to other countries? It could. I'm an optimistic person. I pray that it's that they don't expand that list, and also that they end the current pause. It's just extremely discriminatory and very inhumane is the word that I'm looking for. But could it be expanded? Your guess is as good as mine. It could be, but right now it is those 19 countries. So I'm hopeful that we see some positive change on that front, because I know it's heartbreaking, for individuals who are going through the process, but Egypt is not on there right now. I hope that helps answer your question. It's not, it's definitely not, it's not a good situation. And it looked like Daniel. Yeah. Oh, yeah, Daniel, I know. It's heartbreaking. So you said your wife is about to file removal of conditions. She's an LPR, one of the 19 slandered countries. Yes. And we decided that the risk of travel is too much for her, for international travel, to spend Christmas with her family, which is a bummer. It's yes, my heart hurts for you and for anyone who's in this situation. It's extremely disheartening. And thankfully, you're a U.S. citizen and able to travel there to deliver supplies. That's nice that you're able to do that. Yes, with the current pause and anyone from those 19 countries, we are recommending as well. The pause did not indicate that travel was not allowed for lawful permanent residents, but as wanting to be, if you're someone who's very risk adverse, which I always am for my clients, because we want you to be safe, it is our recommendation as well to reconsider travel. There's just too many unknowns right now for individuals in those 19 countries specifically. All right. And I was just looking to see, Rochelle, if you had any follow-up comments or questions. All right. So Maria, good morning to you as well. And you're happy to be here. We're happy to have you. And your question is, will a U.S. sponsor and letter of support of family members to come and attend the wedding in the USA have any negative impacts on the existing K-1 application for the beneficiary? I think you're asking if the U.S. petitioner were to provide letters like invitation letters or letters of support for a tourist visa application. Am I understanding that correctly? I think that's what you're asking. So like if your family members are applying for a tourist visa to be able to come and, and be present for the wedding, if that would negatively impact your application. So, okay, good. Yes. Thank you for confirming. I don't want to go down a path and answering a question that's not, not your question. So, I mean, it's completely fine, as a US citizen, if you are wanting to provide a letter for your future in-laws to be able to come to the wedding, always be honest, make sure any dates or details that are provided in those letters don't contradict with anything in the fiancé visa application. And that's completely fine for a US citizen to do that for their future in-laws to be able to come to the wedding. Tourist visas are extremely difficult to obtain. And those letters can be helpful. I don't see any direct negative impacts on the fiancé visa application as a result, so long as, like I said, you're very careful in the details that are shared in the letters and that there's no contradictory information, right? So good luck with those applications. Hopefully they are able to receive the ability to a visa to be able to travel for the wedding. I know how important it is to be able to have family present. All right. And Lisa, you're here. You made it. So awesome. Glad you got to be with us. And like always, you're running all over doing all kinds of things. We always want to see where's Lisa at. So you flew to take care of some stuff for your son. So that's awesome. We're really, really happy to have you here today. You're very welcome, Maria. I'm glad that was helpful. We love your photo. Okay, who's next in our queue? Oh, yeah. Okay. So you had your immigrant visa interview on December 5th. Your case was refused under Section 212F, and your wife is a green card holder, and her oath ceremony on the same day was canceled due to the new law. I'm really, really sorry to hear that. That's such a difficult position to be in, especially with her oath ceremony being canceled. To try to find some hope, give you some kind of message of hope. I know there really are no words for anyone who's in this situation that's going to make you feel better. I know that. And with the oath ceremony being canceled, like I said in one of my videos, right now the policy is a pause. It doesn't mean a denial on the ability to become a U.S. citizen or a full denial on your ability to remove conditions or complete the petition process. So hopefully, she'll be able to be rescheduled in the future for that oath ceremony. But I know it's extremely disheartening. All right. And good morning to you as well. I like the name, living on the dream. All right. Okay. So you're at the beginning of your fiancé visa process, and you're needing an I-601 waiver due to a prior overstay because of a cancer diagnosis and you having to take care of him. I'm really sorry to hear that. And can you apply for an expedite request? He's 86 and he needs me. I thought I saw another part to your question. There you are. There it is. Yeah, you said you're in Costa Rica. Okay. Well, it's great to have you with us. So if you are needing a waiver of forgiveness for time spent in the US without documents, you're right. I know you're asking this because the process is very lengthy. To get through that waiver process, just the waiver piece, you're looking typically at around 3 years right now. Is there a way to receive an expedite? So there is There is a tool or a mechanism called an expedite request where you can ask in urgent situations to have your case reviewed faster. I will say expedite requests specifically for waivers are extremely, extremely, extremely difficult to get approved. I've only seen very, very few in that context of a waiver case, and it's because immigration, they require you as part of that I-601 waiver process to prove extreme hardship, that the US citizen would suffer to a level of extreme hardship. So by default, everybody who has an I-601 waiver is typically having to prove those extreme situation, that an extreme situation. And then what happens is when you try to expedite, USCIS almost always comes back with a blanket response saying, we can't approve your expedite because that means pulling you out of line and putting you in front of others. And everybody who has an I-601 has an extreme situation. So that is what I have seen in practice. That is typically what happens. That doesn't mean you can't try, but I want you to have some, realistic expectations of what that looks like. But it looks like you're just getting started on that fiance visa process. I really hope that you have an immigration attorney helping you. What we do for our clients, we can't control the wait times, but being proactive and working ahead, that's something we can control. Being ready for the next steps so things can move forward as quickly and as seamlessly as possible. So whenever we have a waiver client, we always are going to order all of your immigration records, make sure we have a complete picture of your immigration history. And then we also start working on the waiver. This is all done simultaneously with that fiance visa petition pending, because waiver applications, they are a beast. They're usually, 20 to 30 different pieces of evidence. We write a legal brief. Usually it's at least 12 pages long, outlining the law and why you meet these requirements or the eligibility requirements for a waiver. So we have all of that ready. So right after, the fiance visa interview and receiving the denial, you're able to move forward right away with filing that waiver to minimize your wait time in that regard. So, all right. I hope that that helps clarify and answer your question. All right. And you're watching from Nigeria. Like I said, it's great to have you here with us. Yeah, it's a really good question. Is there a reason why all applications can't be processed similarly to direct what you're asking is direct consular filing? And you said you're watching from North Carolina, your husband's watching in Nigeria, you're all doing well, and you're going to get to see each other next week. So that's exciting. That's a great thing to look forward to. I've been practicing immigration law for a long time, well over a decade now. And there was a time that if a couple was living together abroad and there used to be USCIS offices abroad, and we would be able to do direct consular filing for any couples who were living together abroad. I did that all the time and it was great. And wait times were also much shorter. So it used to be that way. This administration ended that during their first term, Trump's first term. They closed all of those USCIS offices, and it was at that point that direct consular filing became even narrow and less opportunities for couples to be able to file on that direct consular file path. Also, wait times used to be much shorter, and unfortunately, they've continued to go up. But yes, I agree. I think I wholeheartedly agree. The wait times should be shorter, and there should be an option for everybody's case to be reviewed faster so you can be together. So. All right. Okay, so Sarah, I think you're commenting on your move. So if you're living, I'm not sure if you mean you're living in Chicago until June or you're leaving Chicago in June. Either way, it sounds like you're going to be there for a while. So if Chicago is where you're living, then your address needs to stay where you're living. All right. So you did the right thing in changing your address. I know it's disheartening to have an interview notice and then have it be canceled because of your move, but that's the best thing that could have happened. That's what's supposed to happen is if you move, then they move your case to the appropriate jurisdiction, because you definitely don't want to go to an interview and then they ask where you're living and you tell them and then they say, well, we have to transfer your case or deny your case. So hopefully your interview will be scheduled here again soon. All right. All right. Let's see. So Monica, you were married. Your virtual Utah marriage, you met in 2019. You received a request for evidence for your I-130. Need to consummate. Deadlines will be February. What happens if we can't comply? So, Monica, I think you're asking. Okay, so you said we're already submitted evidence, documents, pictures. We've been together. We don't know if we can send any other documents. Is there any way that you can justify your marriage? So, so Monica, if you have not responded to your request for evidence yet, don't. Make sure that I don't know if you're working with an immigration attorney or if you've done this on your own. I highly recommend you have an immigration attorney help you with this response. The virtual marriages, we have couples who've used virtual marriage. We've gotten them through the process successfully. But you're right. There are additional requirements. There's a consummation requirement that is really important to prove. And there was actually a policy that came out recently that emphasized the need to, if you're getting married by virtual marriage, show that consummation requirement. If you were not, so what does this mean? I guess I should back up. What does it mean? How do you prove consummation? No, they do not want a video or anything like that. They need proof that you were physically together after the marriage. So it's really imperative that for virtual marriages, we recommend our couples, if they're going to use virtual marriage, that they be together for that marriage on the same Zoom screen. If you're on separate screens, that can add a layer of complexity indeed. So first and foremost, that if you weren't together, you need to have significant and very clear and convincing proof that you were together post marriage. It sounds like maybe you have submitted evidence that shows this, but with the request for evidence, if immigration's not convinced and you submit more of the same, what's going to happen is a denial. And I would hate to see that happen in your case. So, like you said, what happens if we can't comply? If you don't have convincing evidence, if you can't show that requirement, they can deny your case. And I know you've waited for a long time, and I don't want that to happen. So if you are working with an immigration attorney, you should speak with him or her about this is what we've already submitted. What is evidence that clearly puts us together post-marriage is going to result in the strongest submission? And there really should be a legal brief or argument that's included from an attorney with that submission to give you the highest chances of success. I'm happy to meet with you in a private Zoom consultation or by phone. If you don't already have an attorney, you're not obligated to use our firm, but we have a ton of experience with virtual marriages. So I'm happy to help you with that. And Ria can throw my scheduling link. I think I have an appointment, maybe two, available this week. So you can check that out. Ria threw that in there, and I'd be happy to speak with you, Monica. All right. You've been waiting a long time. You definitely want to get your case approved. All right. And I'm just looking, Monica, to see if you had any follow-up, if that answered your question. All right. Great. Sarah, we'd love to speak with you in private too. I always like meeting, I see your questions here. And then when I get to meet with individuals in a private setting, it's really nice to connect in that way so I can give you clear strategic legal guidance in private for your particular case. And I see you were asking about the consultation fee. So we charge $350 for the consultation. And right now we're actually running a special. I realized I didn't mention that at the beginning. So for the rest of the month of December, if you book a consultation and then you decide to move forward in working with us, we're giving you a double credit. So you'll receive that $350 back towards the cost of your case plus an additional $350. So you'll receive $700 off of the legal services when you begin your case with us. So within a week of hiring. So we are running that special to the end of the month as well. Okay. I saw some other questions in here. I'll get to those here in just a minute. Just gave me a chuckle with somebody saying a monster amount of evidence. All right. All right. So Texas and UK, you're back here to learn. We're great. We're happy to have you back with us. The I-130 spouse submitted 5 weeks ago. So you're just waiting. You're doing well. We keep smiling with daily video calls. And they're massively appreciated. I'm really happy to hear that. That makes my heart happy. You're 5 weeks in, so you're 5 weeks closer to being together, and definitely lean on this community here. Knowing you're not alone in the process is really helpful. So great to have you here. Um, okay. I don't you're you said that you have a question. I don't see a question. It says your fiance visa total process in 2025. Please call my name. I'm not sure if you're asking how long does the process take? So he isn't oh, I think that's what you're asking. How many months will the process take? And that you're watching from India. So the fiance visa right now takes about this is an estimate here in December of 2025. Estimates, wait times change all the time, but right now what we're seeing is about 14 months, give or take, for to actually receive that fiance visa in your hand to enter the U.S. The wait time is composed of the very first step, the petition, which takes about 8 months right now, and then there's a long transfer process. The National Visa Center assigns a case number, and then it moves on if you're in India to the U.S. Embassy in Mumbai. That process is another 4 months, so that gets us to about 12 months, and then finding an interview date. So about 14 months to receive that visa in your hand. Then from there, you'd enter the United States, get married, and file for a green card, and that's the final step in the process, but about 14 months. All right. Okay. So this was the question. I think you were the one that had said something about a monster cover letter. When submitting your I-130 and planning to submit a cover letter on issues that we feel would benefit from clarification, should we submit separate cover letters at each stage, thus only addressing the issues covered by the DS-260 when submitting that form, then addressing issues of joint support and establishing domicile? I'm unsure of whether to submit one monster cover letter with the I-130 and risk overwhelm, or submit separate cover letters with each subsequent form addressing only the issues concerning each form. So, all right. It's a good question. It's a big question. Yeah, like I said, I really appreciated the monster cover letter. All right. So, cover letters are fantastic. We use them all the time here at our office. Cover letters provide a very clear roadmap for the adjudicator of what's included in that submission. There's a lot of applications that can be filed online now, which has been helpful, but sometimes we still are submitting a cover letter if there are aspects of the law that need to be clarified. You have to be careful, though, with submitting a cover letter. It's great that you're thinking ahead, but you're right. It can cause overwhelm, confusion, and then an oversubmission. An oversubmission, over explaining too much evidence is actually a red flag. So you have to be very careful. The petition phase of the case has specific eligibility requirements that you need to prove, mainly that you're legally eligible to marry and that your marriage is legally binding and that it's a bona fide relationship. The adjudicators are looking at those aspects of the case. Throughout the process, there are other things that will need to be proved, but right now that immigration is singularly focused on those aspects of the case. If there are things that you think are confusing in the evidence or worth clarifying, I'm not sure exactly what details, but sometimes there are situations where our couples have a more complex relationship history. Perhaps they were previously married and divorced and then remarried, or had a previous relationship or prior marriages or prior immigration cases, that there's more complexities to their relationship history. And in those situations, I'm very meticulous and very strategic in explaining clearly what will be helpful for the adjudicator to know in going into their review, but it's a balance of not over explaining and raising more red flags. So that's a long answer to say cover letters are great. Make sure your cover letter is focused on the eligibility requirements for that particular phase of the case, and be careful that you are clearly explaining things and not introducing potential contradictions. One of the things that, and I will say, you aren't required to have an immigration attorney in your immigration case. It is possible. Could you get through the immigration process on your own? Yes. And are there significant risks in doing your case, DIY? And I will say, I would be remiss for not mentioning that I've had individuals who've written, like you're saying, this monster cover letter over explaining things out of an abundance of caution, which I appreciate, wanting to make sure the adjudicator is clear. But then they get to a point in their case where it has raised red flags for the adjudicators, and they've unwittingly or accidentally introduced, contradictory information. So that's all to say, I can't emphasize enough, just be very, very careful with your cover letters. All right. If you're working with an immigration attorney, definitely speak with him or her to make sure, that you're explaining what needs to be explained in the and only what needs to be explained in the most clear way possible. Oh, you're welcome, Lisa. It was great to see you. I hope you have a fantastic day. We'll see you soon. All right. So hopefully that helped answer your question. I was just looking to see if there were any other. All right. Andrea, I think your question was next. I thought I saw a question from Callie too, and I want to make sure I didn't skip it. I did. Sorry. I know I saw your name, Callie. Hopefully you're still here. Okay. Okay, so let me see if I'm gonna read your question. It's a longer one and get a drink of water while I do that. Okay, so I think your main question I think your main question is about the public charge piece and the proposed public charge changes with Medicaid. I mean, I know this is a big question. You have a lot of moving parts. Right now, that if you have an I-130 petition and if somebody needs an I-601A, the process still requires a departure from the United States and then a re-entry after. Well, you have to do a waiver, get an approval, a departure from the United States, and then a re-entry after approved at the U.S. Embassy or consulate. So that's still currently the process. I would love for there to be a change for the adjustment of status, because you're probably talking about the parole program that was very short lived last year. And I'm not sure if you applied for that or if you received an approval on that. And then in terms of Medicaid, the use of public benefits is not allowed by the immigrant beneficiary. But if family members use government benefits as U.S. citizens that they're rightly entitled to, it should not have a direct negative impact on the immigrant beneficiary. There is rather a current proposed policy amendment for the public charge, and we are seeing proposals and conversations within immigration about expanding the questions on the forms about public charge and inquiring about family members. Right now, though, as a U.S. citizen, if you're going through the process, if you and your family are using Medicaid, so long as it's not the immigrant beneficiary, there wouldn't be anything right now under current policy that would cause any kind of delay. I know the amount of policy proposals and changes, like I've said on the last live, there have been more than 400, and I know it's hard to keep up with all of the different moving parts, but that's where we're at right now. Okay, and then Andrea, you were next. And your photo's sweet. Is there a way to expedite the green card process of the beneficiary? My husband has a job waiting for him and me, and the U.S. citizen, has been informed of a serious illness. We currently live in the U.K. I'm really sorry about your mother having a serious illness. And the job offer is. I wanted to see if you mean has a job offer waiting for both of you. So I think do you both have a job offer? Is that what you're saying in the U.S.? And are you currently living abroad, and have you already filed the I-130 petition? Those would be all of the questions that I would have to be able to answer yours. So yes, there is a process called an expedite where you have to show extreme reasons. I will say that immigration historically, if there are health issues for the U.S. citizen parents, um, that typically in and of itself is not viewed by USCIS to rise to that level of an expedite request being granted. However, when there's multiple factors like a potential job and things like that, there could be a basis. Expedite requests are not it's not a one size fits all. Every case is unique and there's lots of different factors. And whenever we do an expedite request, I look at everything, all of the potential expedite request bases, and then form a legal argument along with supporting evidence. I call immigration, I speak with an agent, I put in a request, we provide a legal argument about why the situation should be considered for an expedite. We have had them approved. They're hard to get approved. So it is possible. All that to say, it is possible. If you haven't filed your petition yet, if you are living, you both are currently living in the UK, we need to talk about something called a direct file. All right. Our firm has had tons of success with direct consular filing cases when the couple is living abroad. And we've actually had quite a few recently from the UK. And so that puts you on something called a special fast track to have your case reviewed directly through the embassy. We've helped people obtain their green cards in less than 4 months. So let's jump on a call if you have not already filed your petition, and let's talk about possibilities for getting you on a fast track and how we can help you with that for direct consular filing. And Ria could probably throw my video in there where I talk about this specifically. All right, I'm going to do a few more questions and then I have to jet. I need to get lunch for this afternoon, and we have a lot of cases that we're moving through, which is good. All right. Yeah, Daniel, that's a great question. So I'm part of the American Immigration Lawyers Association, and I will say there are a lot of lawsuits that have been filed this year against the current administration. Are we likely to see a lawsuit? Probably. Right now, the American Immigration Lawyers Association we are waiting to receive more guidance about how this policy is going to actually be applied, because we need those details, to be able to file some kind of lawsuit. So yeah, it's going to be a very litigious well, we have 3 more years. It's going to be a very litigious time with all of the policies. And, our firm has even filed something called a mandamus action in cases to sue the government for unreasonable delay. There have been situations this year where immigration has made a decision erroneously. They've misapplied the law. We've had to file appeals. So my colleagues and I are doing all of that as well. I anticipate that we will see lawsuits and we will see a lot of pushback. So yeah. All right. Yes, fabulous. I get excited whenever someone starts to give me a fact pattern like that. That's our jam here. If I can get you on a fast track, I'll get you on a fast track. So I look forward to talking. Yes, it's really annoying, right? To be um to be going through a process and you love someone. I know, I speak from the heart. My husband and I went through the process. I get it. To be like, I love this man and we just want to get through the process and live together in peace, and then have to prove and overprove. I totally understand. And to switch your mindset so you don't let the frustration of the process in this administration get to you. My husband and I, when we were going through our process, really looked at it as, yes, we have to prove our relationship, but let's make it a way of like documenting memories, like an extended scrapbook. So now when we go back and look at our applications and see, our relationship timeline and our photos and having and the letters of support, having all of that documented, actually, it's a very lovely thing to go back and look at. And really, when you put it together, when you put the application together, it can be a positive thing for your union. I know it's frustrating though. All right. Thank you. I like them too. I think they're fun. Anything that has a heart on it. My husband got these for me. Anything that has a heart, I have to get it. It's just in alignment with my work in the world. All right. I am going to try to do 2 more. Okay, good, Callie. You're still here. Hopefully you heard my answer to your question then. I'm glad that yes, it is a good point. It's lovely to go back and look at. We actually did that recently. So, yes. All right. I'm just going back here. Miguel, I think you were next. So your wife will be filing her removal of conditions. Can you tell us more about the affidavit from two other people, which is required along with the application? Yes, I can definitely do that, and you're very welcome. So, letters of support are a really great and an important piece of relationship evidence, and they are required for removal of conditions. You're absolutely right. And the letters should be detailed. I mean, they should picking the two people to write these letters is something you should give a lot of thought to. Who are two people who know us very well, who have seen us interact, who've spent time with us, who can attest to our daily life and truly have a lot to contribute in terms of how they know for certain that our love is real. So that's starting with that, and then having them provide details in their letter, and making sure, most importantly, that you go back and review those letters and that they have the timeline and details accurate, because those individuals can be questioned by immigration and you can be asked about their statements as well during an interview. So yes, having them provide as finding those two people and then having them provide as much detail as possible about what they've seen in terms of your union. All right, and then on our website, immigrationforcouples.com, I have a whole section about removal of conditions, and you can even download the free chapter of my relationship evidence guide, and I talk about all the different kinds of evidence that you should include, and other details about the letter of support. So good luck with that, with the process. Okay, so how many chances to get your spouse visa approved at the interview? So it's a one-time shot. You need to make sure you file a solid petition, that you have a solid packet of evidence required, and relationship evidence when you go to the interview, and you need to be prepared. I see you say that you're from Pakistan. So you go to that interview, you want to make sure you're prepared. They're going to ask you questions. They're going to make a decision that day. If they do not believe your relationship, sometimes they can give you an opportunity to provide evidence directly to the embassy. But what typically happens is, if that officer has any doubts, they will refer your petition, revoke it, send it back to USCIS. So could you apply in the future? Yes, but essentially it's a one shot. You have the one shot. So you want to be prepared. All right. So I do need to jet. We're well over our 30 minutes here today. I stayed as long as I could to do as many questions as I possibly could. These are really great questions. I will be back next week, Wednesday, if I'm not mistaken. Like I said, be sure to subscribe, follow, all of that good stuff, and you'll be notified when my next live is. And then let me tell you for certain. Yes. Yes, Ria had put it. Yeah, Ria, we did. We put it for next Wednesday, right? Yes, December. Yes, next Wednesday, December 17th. I will be doing a live. Just so you all know, I'll be here and you can ask those questions. Any other questions you have, we'll get to them next week. All right. Oh, and Maria, thank you for the thank you for the shout out about my feature in the Orlando Voyager magazine. Yes, we were very, very happy for that highlight. All right. All right. Yep. Ria put it in there. Thank you. Wednesday, December 17th is our next live. So I'll be back here next week to answer your questions. All right. All right, everyone. It was great to see you. Take care. Have a fantastic week. Take care of yourselves. Take care of each other. Please don't lose hope. I know it's a very difficult time right now. We will get through this. Focus on the things you can control. Focus on your relationship, maintaining that communication, dreaming about the future. The finish line is in sight. You'll get to it. So hang in there, and I'll see you all next week. All right, everybody. Take care. Bye.